This program is presented by University of California Television. Like what you learn? Visit our website or follow us on Facebook and Twitter to keep up with the latest UCTV programs. Also, make sure to check out and subscribe to our YouTube original channel, UCTV Prime, available only on YouTube.
Okay, welcome to panel 3. The panel, I'm going to start anyway. The panel on the politics and principles of restructuring. I'm John Elwood. I was rude this morning. I'm professor at the Public Policy School, the Goldman School at UC Berkeley. We have a distinguished panel today. We are going to, the panel's going to sort of give presentations in order in which they're in your book, with one exception, which is that Charles Sakai unfortunately could not be here today, which does give the 3 folks who are going to speak extra minutes. So I'm going to give them 18 to 20 minutes to speak rather than the 12 to 15. I'm going to keep these introductions very short, but we're going to start with the judge, Judge Chris Klein, who's the Chief Judge of the U.S. Bankruptcy Court of the Eastern District of California, and he has participated in the various court cases that came out of the Stockton bankruptcy. These opinions, his opinions are on the website of IGS if you want to read the actual opinion, but he will be talking about that. And we've asked him to sort of lay out the law and the rules of the game and how the process works. And then we're going to 2 other speakers. The first will be Bill Brandt, who's President and CEO Development Specialists, Inc., and DSI Civic and Chair of the Illinois Finance Authority. Illinois always has problems with pensions, so that's appropriate.
It's true.
The final speaker will be Guy Davidson, who's Senior Vice President of Alliance Bernstein, who's also in this business. So without further ado, Judge, you're on. Oh, let me say one thing. When we get to the Q&A, and hopefully I'll have a Q&A, when you stand up, please say who you are, and we'll give you a microphone so that everybody knows it, and we're also recording this, and that way you'll be there for posterity or until we wipe out the tape. Okay, Judge.
All right. Thank you, John, for the kind introduction. You notice we lawyers focus on words precisely. He said he's going to lay out the law, not lay down the law. We'll do that in the courtroom. And I am the judge assigned to the city of Stockton case, which constrains some of the things that I can say. I'm not going to speculate about anything that's going to happen in the case. In the future, I'm only going to talk about what I have already ruled in the case in public to the extent that I refer to it to assist the points I'm going to make. Rather, I'm going to lay out what Chapter 9 is and what it is not, because I find that there's a lot of misunderstanding, even among bankruptcy professionals, because it is so very different than the Chapter 11 that most restructuring professionals know and love. The point to start, and the point I think you'll take away from it is that Chapter 9 is a tool for dealing with some of the problems of fiscal crisis that you're talking about, but it's not a solution. It's just a tool. You're not going to. It's not going to provide any kind of a magic answer. Where it comes from is it starts with a quick review of the U.S. Constitution. You know, the Constitution has this contracts clause in it that says that no state may make a law impairing the obligation of contract. And that is, of course, a key concept in our entire economic life. And as we think about it, what economist ever makes an economic argument without assuming that contracts are enforceable? That's, assumption number one. And that's just a key that's there. But it says in the Constitution, no state may. Notice that it does not say Congress may not. Rather, there's another clause in the Constitution called the Bankruptcy Clause, which gives to the Congress the exclusive authority to legislate uniform laws of bankruptcy in the United States. Well, what is a law of bankruptcy? Well, if you think about it, a law of bankruptcy is how we deal with ways of treating people fairly when we're not going to enforce contracts. In other words, bankruptcy is all about impairing contracts. I've been on the bench 25 years. I've now had more than 135,000 bankruptcy cases assigned to me. There are untold millions of contracts that I have presided over the impairment of. That's just part of the key assumptions in bankruptcy. And not only is the bankruptcy clause there, and there as a balance with the contracts clause, I think you can see that it's that asymmetry is absolutely intentional on the part of the drafters of the Constitution. But there's also the supremacy clause. So once there is a case under the uniform laws created by the Congress, the supremacy clause winds up causing that law to trump state law to the contrary, or as I pointed out in one of the Stockton decisions, also trumps the state constitution on the same point. So the point is, the point number one is that a state, while it can have an insolvency law, cannot grant a bankruptcy discharge because that would impair a contract. The Supreme Court dealt squarely with that question in a case called Sturgis v. Crowninshield back in 1819. And there's never really been any debate about it. Well, that concept just sat there dormant until the Great Depression. In the Great Depression, there were lots and lots of entities, mostly special financing districts, road districts, and the like, that became irretrievably insolvent. And the answer and they had bonded indebtedness, and when the holders of the bonds said, well, raise your levies, the answer was that people just moved out. The levies got too high. They moved down the road to where the levies weren't so high, and a phenomenon was observed called the death spiral. And eventually, these places just went to zero population, and that ultimately was the Armageddon. Congress enacted a bankruptcy statute known as Chapter Roman 9. There were Roman numerals then. Back in 1935, I guess about 1933, and the U.S. Supreme Court held it unconstitutional in 1936. And the reason that it was held unconstitutional in 1936 was twofold. First, it was that group of judges that were holding New Deal legislation generally unconstitutional. And Mr. Justice McReynolds, who wrote the decision, said he just couldn't wrap his mind around the proposition that, wait a minute, you're talking about sovereign debt, and he could not understand how in our federal system you could deal with sovereign debt in a Chapter 9 case. It would just boggled his mind. His second point was that the particular language of the statute gave way too much latitude to the federal judge to interfere with the management of the government entity. And there was language that said that the judge can interfere with revenues that or with decisions that, in the judgment of the federal judge, are not appropriate. I'm paraphrasing only slightly. So in any event, that was unconstitutional. Congress revised the statute to clear up that problem. After the Roosevelt court packing matter, it came right back up, right out of California, as a matter of fact. It was an irrigation district out of Kings County. The judge there held the new Chapter 9 unconstitutional in September of 1936, and in March of 1937, the U.S. Supreme Court decided the case. You wonder about how long cases last in the appellate system. It was pretty fast back then. It was called United States v. Beacons, and the fundamental concept the Supreme Court adopted in concluding that the reenacted Chapter 9 was constitutional was the notion that Chapter 9 reflected a kind of a compact between sovereigns, the federal sovereign and the individual state sovereigns. And the reasoning was that, well, we let the various state sovereigns have compacts that are approved by the Congress, interstate compacts, and so on. It's apparent that the state sovereign could not accomplish the end of discharging a debt, and that was clear back from 1819, and the Supreme Court saw no reason why, with appropriate limitations, the states could not enlist the power of the federal sovereign, always subject to the 10th Amendment and making sure that there's no interference with the governmental exercise of power by the state sovereigns. So that's the constitutional basis of where we go. Chapter 9 at that point could only deal with bonded indebtedness. And it was clearly a model seeking a prepackaged plan of, well, it was then called the plan of arrangement. Literally, it could not be filed unless there was already a plan agreed to by 75% of the affected holders. In other words, it was just created to deal with the so-called holdout problem of getting the final closure with the minority. That sat on the books till 1976. In 1976, remember what was going on in municipal finance? That famous headline in, was it Ford to New York, dropped dead? Well, the city of New York was in dire financial trouble, and Chapter 9 was revised at that point to permit dealing with any kind of debt of a municipality. There was just a sense that it needed to be modernized, and so that's when the basic Chapter 9 that we have today was enacted. It was enacted in advance of the Bankruptcy Code, which was then enacted in 1978, and so there's a reenactment of Chapter 9, and that is the provisions that we have today. But it was largely set in concrete in 1976 under the former Bankruptcy Act. Now, the key concept is that at the end of the process, there can be a discharge of the debtor of debts. And the lawyers in the room know this well, but a lot of other people don't understand that a bankruptcy discharge does not discharge other obligors on the debt. I see people all the time that are in their own bankruptcy situation because they co-signed a debt for somebody, and when that person got discharged out, the creditor came to them and said, look, you co-signed, you guaranteed, whatever, you're on the hook. And the answer is yes, because the bankruptcy discharge, as a matter of law, does not affect the liability of anybody else obligated on the debt. So individually, if you're in an automobile accident and you get a bankruptcy discharge, your personal liability for your personal liability for your negligence in the auto accident is discharged, but your insurance company can't hide behind that. They have to pay up. So that concept is important, and that's one reason why a number of the players that have showed up objecting in the Stockton case are insurance guarantee operations. Specifically, given that you're in municipal debt, you're dealing with sovereign debt where you can't sue the sovereign, get a money judgment, and you can't levy on City Hall or the state capitol and sell it. The conventional answer is, the answer of all economists is, well, you can insure against it, right? And so there are all these monoline insurers out there, and a lot of municipal debt has payment guarantees on it, and it's the guarantors who are a number of the guarantors are showing up in the Stockton case and asking to be heard because it's their money that's at risk if the relevant bonds are not paid. So that's the key point about the discharge, and then that gets me to Chapter 9 itself. Chapter 9 is intensely a negotiation model. Chapter 11, the Chapter 11s we all know are themselves negotiations, and the professional reorganization people in the room will tell you that the successful Chapter 11 reorganizations in the end are all consensual, often after bloody battles, and many bloody battles. But in the end, they're all consensual, or most of them are. Even more so in Chapter 9. And the reason is that my power as a judge is greatly limited in Chapter 9. There are only really two places where my role is important in the case. First is, unlike other bankruptcies in the United States, in a Chapter 9 case, you have to litigate your way to an order for relief. So on one of the presentations this morning, the essential elements of getting the order for relief were laid out, how you have to be a municipality, have to be authorized to file, and that's what is commonly referred to as this AB 506 provision. I think it's actually California Government Code section something or other applies, because the state has to grant permission. And I would point out that not every state has granted permission, and some have done it very limited extent. In Oregon, as a matter of fact, you have a Chapter 9, but only if you're in an irrigation district. That's it. Of course, you could always have an act of the state legislature, especially authorizing a Chapter 9 case to be filed. And as we learned in the New York off-track betting case, the inherent authority of the governor of the state of New York as a matter of New York state constitutional law authorized him to execute to authorize a filing by executive order. So I mean, there are all sorts of other ways, but California has a standing statute that operates as the gate and the gatekeeping. And then one has to be insolvent, and there's a special definition of insolvency. One is not currently paying, generally not paying debts. And the alternative is not able to pay debts as they come due. Well, that causes some people to have the misimpression that, well, that means you can look out and do kind of a balance sheet and discount all future liabilities to present value and say you're hopelessly insolvent. But in fact, the case law that's developed going back to cases like the city of Bridgeport back around 1990 say that no, there's a very temporal short period. You have to be, in effect, insolvent, unable to pay within the next couple of years. So then finally, there has to be desire. Well, there has to be a desire to negotiate a plan, to have a plan. There's a pre-negotiation requirement, and then the case has to be filed in good faith. In Stockton, a number of those matters are apparently going to be litigated. The parties are in discovery right now. I'll probably have a trial on that in January. And if I order relief, then the case goes forward. If I don't order relief, the case would be dismissed. If I do order relief, I'm basically done. The bankruptcy court itself is basically done until a plan of adjustment is presented to the court. And then it's the court's obligation to review the plan of adjustment and determine whether it's fair and equitable as to all parties. That can be very extensive litigation. The court can say, well, this plan doesn't work, and authorize somebody to come back, and so it winds up being an iterative process that is highly negotiated among the parties. And in the end, Vallejo was a consensual plan after a great number of bodies on the floor. Finally, I say I have no authority there. The only other leverage I have is dismissing the case. But if I dismiss the case, there's nothing to stop me from turning around and filing again. So that's the limitation. Early on in the Stockton case, the Association of Retired Employees came to me, wanted me to enjoin the city from adjusting payment of retiree health care benefits. there's a section in the bankruptcy code, section 904, that says that I cannot interfere with political or governmental powers, that I cannot interfere with the city's property or revenues, and I cannot interfere with the city's use or enjoyment of revenue-producing property, which caused me, in a decision that's on the website, to say, I'm sorry, there's nothing I can do. And it doesn't matter whether what the city did is right or wrong or fair or unfair, too bad. So that's the quick overview of Chapter 9.
Thank you. Thank you very much. As I indicated before, our second speaker is Bill Brandt, who is President and CEO, Development Specialist, Inc., and SDI Civic and Chair of the Illinois Finance Authority. You're on.
Hi, I'm what Jack Citron would call the outside agitator here at Berkeley, which is a moniker I wanted to use for a number of years since I watched the demonstrations back in the 60s. But by that I mean, I've been in the bankruptcy and restructuring business for almost 40 years. In 2007, Governor Blagojevich, yes, that Governor Blagojevich, called me in one day and said, we have a problem at the Illinois Finance Authority, which is the nation's largest state-sponsored bond issuing agency. California may have more bonds issued, but Illinois in 2004 decided to put them all together and make them issued under one agency, largely under one agency. So I have been working through the IFA now for 5 years, and I discovered as I read the statute, much to my surprise, that it put me in charge of all municipal insolvencies in Illinois. So I have had now 5 years track record running through the municipal insolvency issues and dealing with them. And so one of the issues I wanted to talk about was, why are we here? Because there was an earlier question, I think, to Mark Zandi, my old friend Mark Zandi's answer, you know, don't we have a conflict here with S&P, and didn't they give us the great debacle in the Great Recession when they basically missed the game on all the subprime mortgages? Well, just after 2011, Meredith Whitney, you recall, went on 60 Minutes, and she said, my God, the sky is falling. There's going to be 1 million defaults in the municipal bond market, and we're all going to run for cover. Right after that, I got a call from the National Association of Insurance Commissioners. Now, if you think about it for a second, most of the insurance companies in the country, which they oversee in their various 50 state offices, hold as a key element of the debt they carry for future work municipal bonds. And so they brought me in and they said, my God, what if the rating agencies have it wrong again? And what if we're about to go on a subprime binge and they're all wrong? Can you help us out? And I said, I can. But I want you to understand something. If you're sitting on the other end of a phone and a broker calls you and says, I want to sell you a municipal bond, all of you, and I mean all of you in this room, have one thing in mind, what I call your grandfather's municipal bond, and that is a bond issued with the full faith and credit of the state of Illinois or the state of California or a respective municipality, which says, I will never default on this bond, and if I default on this bond, full faith and credit means I will go back to the citizenry and I will say, folks, sorry about this, we have to make good on this, I'm going to raise your taxes. Those bonds, my friends, are the safest bonds you can buy. In fact, they're so damn safe that today they are paying an interest rate roughly approximate to what they paid in 1925 when they first started being issued. You'll get about 1,200 basis points, 1.2 today in the municipal market. It is not a real sexy bond. Are we here because those bonds are about to default? Folks, no. All right? Why are those bonds issued? Those bonds are issued because none of us pay taxes, at least property taxes and others, in any of the states we live in. We don't pay them on a weekly basis. We pay them sometimes once a year. We pay them sometimes twice a year, depending where you are, or a year in arrears. And so the states issue bonds to cover the tax anticipation. There are other types of bonds. There are revenue bonds. What are revenue bonds? Revenue bonds are a creature of the 60s. A fellow named Robert Moses decided to cover New York in concrete. And when he did that, he issued revenue bonds because he said, you know what I'm going to do? I'm going to issue bonds, and the people who use these entities I'm creating, they're going to pay for the bonds, whether they be toll roads or bridges. And that's what happened to New York State in 1974, as Judge Klein says. The famous drop dead wasn't about the general obligation bonds of New York State or New York City. It was about the revenue bonds that have been raised to support the infrastructure that Moses put together. And why the bankruptcy code was changed, it was initially issued, by the way, in 1933 because the state of Arkansas, the first time in modern history, defaulted on sovereign debt. It blew up on a bond repayment to a road issue that it had done in 1932. Interestingly enough, a year later after the kerfuffle, it paid the damn thing in full. I always ask people, What do these 5 cities have in common? Orange County, well, actually 5 entities, Orange County in California. New York, right after Abe Beame was famously told to drop dead, and actually a good friend of ours, Harvey Miller, was preparing the petitions for the 9, was told to drop dead by Jerry Ford. Hurricane Katrina, or New Orleans, I should say, both during and after Hurricane Katrina. Philadelphia in the 1990s when they famously were way behind, and Miami in the late 1980s when Lawton Chiles said, "I'll never save that third world country at the bottom of my state." I will tell you what all 5 of those have in mind, okay? All 5 of those, your worst examples in least common lore of municipal default, never missed a payment on any interest or principal on any of their municipal bonds. Never throughout the entire episode. Why is that? Well, let's talk about pain sharing because I have only a few moments. Most municipalities spend something on the order, most municipalities in sovereign debt spend something on the order of between 8 and 14%. 14 is pretty high, 8's more the norm, on the expenditures connected to debt service of all forms. Friends, if you are spending 8% of your expenditures on servicing your debt, you are telling me by inference there's 90% of a bunch of other people who can really get some pain inflicted on them before you get around to having to screw up the bond market. Now, Lawton Chiles brought me to Tallahassee, Florida in 1989, and he said, "I'm not going to save that third world country." And as we walked into his anteroom, I saw the chief of staff to the mayors of Jacksonville and Tampa out in his anteroom. Both of them were going to the bond markets in the following week, and they were both going to offer bonds for port improvements. And both of them were looking at the phrase we call in the bond business, a technical phrase, SOL. And they decided that wasn't something that they could really put up with. So I said, "Lawton, you've got a problem. You cannot let Miami do this because every other city in this state will be looked upon by the investors and the rating agencies for what you've just done." So we did what we always do in politics. We formed a Blue Ribbon Commission, announcing soundly when we formed the Blue Ribbon Commission, chaired by Buddy McKay at that point, the Lieutenant Governor of Florida, "We're not going to do a thing to help them, and you're never going to hear from us again." And 2 years later, surprise, there was no default, and somehow the commission disbanded, and Miami got through its problems. And we all know quietly in the state legislature in Tallahassee, this was taken care of. So that's what happens with respect to your grandfather's bonds. Now, when we talk about municipal default, we've gotten a little esoteric. The agency I chair issues or can issue up to $30 billion worth of bonds. They are conduit bonds. In fact, I had a call from Bloomberg last year, waking me up one morning and saying, "Mr. Brandt, we have an emergency. We have to get you on the record." I said, "That's a rare thing for me, but let's start it off." And I said, "What am I being talked about?" And he said, "You are in charge of the largest municipal bond default in this year's market." I said, "Oh, that's kind of cool. What happened? Can you tell me? Who is it? The city of Chicago, Rockford?" He said, "No, it's the Claire." And I said, "The Claire." The Claire is what I call a roach motel. You all call them continuing care facilities, okay, where you check in, you don't check out, you just keep going to higher floors until they push you off the top, okay? Sorry. We have some black humor in the bond business. You'll have to get with it, okay? And so at some point, the Claire had issued conduit bonds. What are conduit bonds? Every state in the union, including California and its RDAs, maintains a bond issuing authority whose role is to foster economic development, jobs, and the rest of it. The bond issuing authority issues bonds largely for private sector development, but through the tax-exempt laws that Congress has allowed on an allocated basis each state to use. So the Claire's bonds were issued by the state of Illinois, by the IFA. They were held, 229 million of them, by a bunch of private investors through a standard private indentured trustee. The state had no exposure. The state had no full faith and credit. The state had no involvement whatsoever other than its name was on the certificate. A bunch of people really lost their shirts. Now, those of us in the bond business, quick bit of bond humor. You all remember when you were younger, because y'all raised your hands until most of you were over 50. Remember those head shops that had the big poster that said, "What are the 14 things to do in case of a nuclear air raid?" Number 12 was sit in the chair. Number 13 was bend over. And number 14 you can remember now, okay? I always tell people when they call me up, like for bonds at the Claire, just skip to 13, buddy, because, all right? Now, can the Claire file a Chapter 9? No, it's a Chapter 11. And the large portion of bonds being issued today are conduit bonds, or even something I call COPs, certificates of participation, which are even great. I knew that we were in trouble, and I told the National Association of Insurance Commissioners we were. When the bonding authority in Moorhaven, Florida, you've all heard of Moorhaven, haven't you? Well, many of you wintered there. You've not. Okay, it's a small agricultural community on the south end of Lake Okeechobee. It issued $66 million in conduit certificates of participation in the public debt markets for the building of a high school. Why, isn't that a heartwarming thing? A high school for Moorhaven. Well, it wasn't for Moorhaven. It was for Guam. They issued a $66 million bond issue in Moorhaven, Florida, paying a yield of over 6.7% for a high school to be built in Guam. Now, it's unrated. Now, if somebody calls you up and says, have I got a municipal bond for you? Your first reaction is, my grandfather's bond. Why, this is the safest investment I can think of. And then the fellow says, safe? Why, I'll beat you safe. It's going to pay you 6.7% in today's market. A municipal bond paying 6.7%. I'm there. Where do I sign up? Well, a couple of things I have to disclose you. One, it's unrated, and two, it's for a high school in Guam. Well, that's not a problem. They use high schools in Guam all the time, you know. So as I sit here and I talk to people and they ask me, what do I think of Meredith Whitney and how is this going to go? Folks, what we've all done, I mean, and I think the judge did a wonderful encapsulation of Chapter 9. You all have a picture of municipal bonds as your grandfather's bonds, as the full faith and credit bonds being issued in tax anticipation strategies by various municipalities. We're way beyond that. The city of Telluride, Colorado, a wonderful place, by the way, a resort sort of the other side of Moorhaven, said not too long ago, we're going to do a certificate of participation issue. What does that mean? Well, we've decided we're going to take most of the city property and we're going to dump it into a blind trust. The blind trust will have a trustee called Wells Fargo Bank. You know them, they got the stagecoaches. And we will put all of this in the trust, and we have agreed, the city of Telluride has agreed, to lease it all back, because we need it, of course. We will lease it all back at lease payments that will structure an income stream yield of over 7.09%, which is real good. Now, I'm thinking, there are people marketing these bonds, certificates of participation, and you've just been told this is an issue by Telluride, and you think, what a deal, okay? I will go look at this. And you read the prospectus, and I'm looking for the prospectus where it says, of course, if we start missing a few payments, or if the parks aren't used as much of the ground, we'll cover you. And there's a paragraph in the prospectus, and it says, you know, we're not so sure we're going to need City Hall a couple of years from now. And by the way, if it turns out we don't need it, we wish you every bit of luck with that collateral. All right? Well, that's what certificates of participation are about. And they're out there, and people are buying them as municipal bonds. So there are a lot of issues I want to talk about, but my time is almost up. I want to talk about debt. So everybody tells me, darn, isn't California Greece? California is Greece. Well, you've all seen that calculation. California is real simple and Greece is real simple. You take the amount of domestic product, you can calculate that for Greece real quickly, and you can calculate their debt, and you can figure out a ratio. And the debt ratio right now that the IIF is dealing with for Greece is about 185. No big deal. Japan's 200. People forget talking about that. That means if you take Greece's entire domestic gross product, and you figure out its one number, and you take its debt is 185% of all the goods and services produced in any year in Greece. That's a pretty daunting number. That's kind of like the rest of us with our credit cards, where we have $50,000 on our credit cards, but we're only making $10,000. It looks like a hopeless prospect. So everybody tells me California is Greece. Friends, look at this. Every state in the union can have a calculation just like Greece. Every state in the union, you can calculate the state's domestic product, the value of its goods and services in every year. And you can figure out just how leveraged it is. California is terribly leveraged. The worst, of course, that socialist state of Massachusetts. I think it's right near Hawaii, by the way, another place in heaven, which obviously is debt-ridden like crazy. What are their ratios? 8%. I didn't say 185, friends. I said 8%, okay? There's a lot of room in terms of the crisis. Tom was right. This ain't Syria, all right? Now, I took the debt and I said, okay, let's talk about the pension debt. Now, it's full accrual, basically. All right, add the current pension debt as if it was a current payable. Not going to be full accrual. Look at it. You get up to Hawaii, you get Mississippi, Connecticut. You get a lot of states that basically are floating at 16%. That's not 185. A couple of last things. Like the Roach Motel, a number of states prohibit and have certain functions they like. They don't like bankruptcy. California is one of the few states that permits semi-unfettered access to the United States Bankruptcy Court. Well, I am a big fan of Judge Klein, and I think he and his brethren and sister do a wonderful job. Bankruptcy is the last place you want any municipality to ever be. And if you look at most of the states east of the Rockies who had a bad experience in the 1930s when their municipalities began going bankrupt, there is a series of laws. 26 of the 24 states essentially prohibit unfettered access to the bankruptcy courts. The misnomer we always hear is a bunch of states prevent bankruptcy. They do not. They have a series of hurdles that municipal people need to go to first before they're allowed to file bankruptcy. Now, are they much like the Roach Motel? You check into Act 47 in Pennsylvania and you don't check out? Yes, okay. There is a price to be paid for doing this, and essentially what all of them are is just what happened with Felix Rohatyn and Abe Bean in 1974 and 76, a municipal assistance corporation, a MAC. A series of professionals came in who do city financing, like our firm and like others in this audience, and took over the finances and put them on a budget and put them on training wheels and worked it out over time. Now, you know, that sounds simple, but if you realize that most of these municipal authorities are not, or municipal officials are not finance wizards in usually community financing, they got elected, they serve 2 or 3 years, and they leave. That kind of support is often necessary. I also get back to John's comment earlier today. Everybody tells me, what is it with Pennsylvania and Illinois? You have a prohibition in your state constitution against altering an existing pension plan for public employees. What a neat deal. Those public employees, what a hell of a lobbying group that they got that in the Constitution. Do y'all know why? Because in 1933, when the Social Security Act was created, public employees were left out of it. They do not participate in Social Security. They do not get it. So if you take away their pensions, half of you have in your mind, oh, big deal, they'll just cash the Social Security check. They don't participate in the system. They will never get one. All they have is the pension. And Congress, in their infinite wisdom, said, you go out and bargain for what you can get. The theory would be, we will pay you a lot less than you can make in the private sector, and you'll work a lot for a lot less dollars over your life, but we'll take care of you in your old age. And because Social Security has such low limits, we'll leave you free to bargain with what you get thereafter. Now, I caution everybody because I deal with the labor unions all the time, and I told John this as well. The constitutional prohibition is all about altering or amending an existing pension plan. It says nothing about OPEBs. OPEBs are other post-employee benefits or, as it was discussed this morning, health care. So I often say to unions, you got me. I can do nothing with respect to altering your pension benefits. I will stop right there. By the way, sorry about your health care, it's all gone. Stops in their tracks. And I say, look, what we're talking about then is actually nothing more than the standard labor negotiation, aren't we? Because the underlying issue here is allocation. I got dollars, we got to allocate. I can't mess with your pension plan, but you get nothing else. Or do you want to sit down and discuss with me what we're going to do on the OPEBs and the other valuations so we can find some way to make this work? Whether we strip out COLAs, whether we do other issues, all of that's possible. One final thing as I wind up. I had Mark Levinson, who's the lawyer handling Stockton and handling Vallejo, once on a panel with me talking about labor union issues. And Mark was telling me that one of the things that drove him crazy was how the firefighters, got all these good deals. Good news to you. And I said to him, Mark, how old are you? Mark said, well, I'm kind of like your age. I'm just over 60. I said, Mark, you ever wake up in the morning, you got a few pains in the knees, you got some pains in the elbows? And Mark said, well, yes, I do. I'm over 60. I said, Mark, you got that from playing golf and occasionally messing with a stapler. You weren't running up a ladder for 30 years pulling people out of a house. I said, I have enough wisdom to determine with respect to first responders, we can put them in a different bargaining class than the guys who were handling and the ladies who were handling the staples. And with that, I will leave it go. John, I did your bidding. At least talk about it.
Okay. My view came through here. All right. Last but not least is Guy Davidson, who is Senior Vice President of Alliance Bernstein. As soon as we get his slides up and going, we'll go.
All right. Tough acts to follow. So I thought today, and I'm going to keep it pretty quick because I think I have the enviable task of following some very good information now and then earlier today. So what I'm going to do is basically stick to my role, and that is that I buy bonds. And I buy bonds for our clients. And And you've kind of heard from an issuer who works on financing. You've heard from some other officials. Now I'm going to give you my take, and that really has a lot to do with what's going on in the market. So basically, there are three things I want to talk about. One, how do we get in this mess? What investors want, and opportunity. Is there an opportunity if you're thinking about restructuring? So the first one, which I would have titled, and I picked up sort of Tom's idea on it, is what crisis? What are you talking about? So I'll kind of finish that up at the end of this, but let's start with this chart here. Since 1995, basically, our traders, at the end of each week, take a look at what California general obligation bond yields are, in this case, in the 10-year range, and they compare that to AAA-rated general obligation bonds in the market. A lot of people do this across the market who are involved, and you can see that fluctuates quite a bit. Now, in part, Tracy brought up earlier, I think Scott brought it up earlier, that there's a lot of volatility in the finances, and it's reflected, quite frankly, in the market value of California general obligation bonds. And that spread is moved from minus, it's gone through. Back in the tech bubble, everyone wanted California general obligation bonds, in part because there's a very big in-state demand, and people were willing to pay through AAA-rated credits, 40 basis points through, and it got as wide back in 08-09 as almost 2% higher. And you can think of that as the time that nobody wanted them. They're all afraid that the Depression was right around the corner. Well, this fluctuation, if you say it's, and I'll just use 2% fluctuation time for a 10-year bond, that can be basically 8 times 2 is, it's 3, it's a 1.5% of price performance one way or the other, and that can wipe out a lot of the income. So there's a lot of uncertainty. Second thing is, it's not just, and Mark mentioned earlier that bond investors or traders end up having a 5-minute ruler. It's not just the traders. There are 30 upgrades and downgrades during this period. Guys with the little green eye shades who are sitting there away from the market are upgrading and downgrading the state constantly based on its prospects as they look forward. And, oh, by the way, as the spreads are coming down now, they're getting a little more comfortable with the economy, and they're willing to give up or buy them at yield levels that are a little more reasonable today than they were just a couple of years ago. So it does feel like some of the crisis seems to be going out of the market. But where is this volatility coming from? Well, here's that statement earlier. You saw the extra volatility on revenue. And it was basic. Look over the left there. This is basically where the taxes are coming from: sales tax, personal income tax, corporate income tax. Very economically sensitive taxes. You have a graduated tax system. You have volatility. But California, if you stop there, you're letting yourself off easy. You have no monopoly on volatile revenue sources, or, quite frankly, a very difficult time in this housing crisis. What you can see here is I put 2 other states up, and this is just looking at their general fund balance. And what you can see, now Florida, I'll tell you up top, they're AA, AAA rated. Nevada is a AA2, AA minus type of credit. They've had terrible housing markets. But one of the things that they've done, because they've maintained their ratings through here, is they set money aside. And you can see going into the recession that they began with much higher fund balances than California did. And this kind of comes back to Scott's comment earlier today, that in California, you have to figure out a way to create an incentive. He said it in 2 different ways. One, and I'll get moving here. One is to take advantage of the good times and set money aside so that if you have a volatile tax system, you have a little bit of a buffer. And the second is not to do bad things, was the other way he said it, in good times. All right, so now the idea of putting money aside, if you look at individual ratings at the local level, you'll see that those who did put money aside, their ratings tended to hold up better. But Michael mentioned earlier, you've got to look at each credit at the local level to figure out what's going on. I will tell you the AV dropped about 4% from 06 through 2010, 2011 on average. that average doesn't tell you much about what each one's going through. Take a look at Los Angeles kind of experienced what happened on average, but look at Stockton and San Bernardino, and then turn around, and I'm actually pulling this data on the right from Scott's website, but this is looking at what their locked-in costs are for just public safety is a large part of their budget, and they have no flexibility, and we end up in court. All right, so what do you, as we look forward, because I have about 5 minutes left, why do we say, where's the crisis? 10. Do I have 10? 10. Yeah. All right, I got 10. All right. So where's the crisis? It is real. I mean, these communities that have gone through the boom-bust cycle, they're having a very difficult time. But why aren't we basically seeing, and Tracy asked me this question, why aren't you seeing the contagion effect? Why aren't you seeing people getting scared? Well, the reason why, and what I did here, and I just use this as a proxy. I could use public safety as a percent of their overall budget. I could look at debt service, whatever you wanted. I just took right here, delinquency rate, 90-plus days on mortgages. If it's above 10%, that's about double the national average. It's also high here. What do you have, 58 counties here? 10 of them, or let's call it a third of them have huge numbers. They're over 10% are behind. 1 out of every 10 is more than 90 days behind in their mortgage. Well, if I add them all up and I say every one of the local government bonds in those counties, and that includes the cities as well, defaults tomorrow, that totals 1.3% of the California market. Then divide that basically, and California represents 15% of the municipal market. So there is not a crisis within the municipal market. That doesn't mean people aren't getting scared, though. In fact, you hear analysts now saying, those guys, if they go start to default to get out of these things, we're really going to penalize them on ratings, and we're going to, we'll see what happens. But the market's getting very concerned, and I would say this, I describe it this way, and then probably the room here describes it well. We have a lot of very interested bystanders at the moment, okay? So, and by the way, I think what's been amazing to me is we've gone through what we've gone through in the last few years in the Great Recession, and you heard, I think the statistics in the Great Depression were something like 15% of the municipal issuers defaulted in the first 4 years. We got all the way up to 1/4%, and it's been coming down since then. So it doesn't look like much of a crisis when you look at just the debt market. Next thing, what do investors want? Well, basically investors want stability. Another way of saying it is when people buy bonds, they buy bonds to stay rich, not to get rich. So they're looking to stay rich. They don't want a lot of risk here. So let's see, but so anyway, I think Bill talked a little bit about the different types of municipal debt. There are state and local government bonds. We also threw leases in there. They're about 1/3 of the market. Revenue bonds, that's your water, sewer, tolls, airports, et cetera. You have your special tax bonds. Most municipal investors right now in this environment with a lot of uncertainty in the market are moving towards things where they have a claim on the revenues. And the judge can get into that and why they want it, but they want a claim on the revenues, and they do not want to be an unsecured creditor, particularly in a time of a lot of uncertainty, which Mark was talking about. So that's what they're trying to buy. And in fact, you can see here, there has been a little bit of a contagion effect. These are local general obligation bonds in California versus revenue bonds. It used to be unlimited tax was the thing you wanted. Not anymore. People would rather have a dedicated revenue. I know it's difficult to do it. You got to go to the voters here. But if you can carve out a revenue source, the analysts like it better. As you can see, Cal economic recovery bonds are rated better than the general obligation bonds. Sales tax bonds in Illinois, Bill's a great state, are rated better than the GO, and Puerto Rico sales tax are better than Puerto Rico. And you can see the financing benefit if you can carve it out. People will pay for that. All right, so then the last thing, what would you do? And this I would have titled, Making Lemonade from Lemons, all right? You've got to take what the market gives you and take advantage of it. If I were thinking about what I could, if I was really thinking about restructuring government, not necessarily deals, and I'm sitting there saying, what businesses do I want to get out of? The market right now will pay you for certainty. The left side of this chart is some great trades that states and some local governments have done. And one of them is basically securitize the MSA payments, okay? That was a risk that they got off their books. Investors own it. It's cost the investors, and look at the financing costs of the general obligation bonds has dropped. To the right now of this chart, What's the extra yield they're demanding for lower credit quality? It's still very high by historical standards. Less than when everyone thought we were going to depression, but still very high by historical standards. They will pay for some stability. So what's stability? Well, toll roads, water, sewer. These are the sorts of things that have a good, stable revenue source. We like them as bondholders, but we started to see some of the securitization of those streams back with Indiana Toll or Chicago Tollway. To the left, so are you going to find good markets, whatever way you decide to do it? In the municipal market, yes, if you're an issuer. It's an issuer's market. Supply is flat to slightly down the last 2 years, and demand is up. The forecasts of default have not come to pass. We are not going to have a 100-year flood. We have a lot of problems. We're all watching to see how Chapter 9 unfolds, but it's an issuer's market, and people want stability. So that's the story.
Okay,
thank you
very much. Okay, we're going to take questions. Did I get my extra 15 minutes back, given that we started 15 minutes later?
No, you used it up this morning.
No, I mean, not personally. I'm simply being nice to the audience.
I'm being cruel, John.
Okay.
How long have you got it on? We have about 12 to 15 minutes for questions.
Really? That's unfair to the audience. Okay, put your hands up, and yeah, David, you have to say who you are.
Oh, hi, I'm David Crane, and thank you for this presentation today. I found it very interesting. I have two questions for Mr. Brandt. One, in California, I thought, I know that teachers are not entitled to Social Security, but I thought other government employees were entitled to Social Security.
It depends on the states and what they've opted in or opted out. Generally, though, most public employees are not in the Social Security system nationwide.
So in California, is there anybody here who knows on California state employees?
Right.
How about at the state? 70% are in?
Yeah, in California.
Most locals are in? Okay, so you're referring to other states generally.
The older states don't have the opt-out provisions that California did, or do. Right.
Second question I have is, on the chart about debt service and retirement benefit service at the state level, and full disclosure, I own California general obligation bonds. I wasn't aware that that anybody thought there was a risk of default at the state level. Certainly not what Meredith Whitney said. She was focused on local jurisdictions. You could raise debt service and retirement benefit service in California at many levels.
Yes.
Without any risk of default, and of course the state can't declare bankruptcy. But what you didn't show on there is the crowd-out effect as those costs go up on other services. So for example, in California, even though state revenues have risen 50% over the last 10 years, state spending on the University of California is down 20% because of rising costs in at least one of those two factors.
Agreed.
So what was the point you were making about rising, about debt service levels at the state level? Are there any states really at risk of default?
No, I think there are no states at risk of default, and I think that was the point of the chart, to say instead of the answer, of course, to the question is California Greece? And frankly, no state is. I mean,
But who's been saying that?
Well, if you look at this, actually articles entitled "Is California Greece" that you've seen floating in the media about the bond issue, and I've tried to tell people, look, at 185% of GDP or 200 if you're Japan, we're nowhere near there. We have a lot of room. Do the issues exist that you suggest for crowd out? Absolutely. And as I said, most expenditures from a municipal basis are somewhere between 8 and 14%. You can raise those and may have to raise those. And obviously, if revenues are down, you may shake that ratio shortly on a short-term basis. But what I mean to imply, and what I'm hoping I said clearly, was there's a lot of other stakeholders in the situation who can suffer a lot of pain before you have to irretrievably mess up your access to the credit markets, which is something that, I ask people. The general obligation bonds in California are often treated separately than a lot of other states' general obligation bonds. One of the reasons we talked about revenue bonds, and the judge can speak to this, revenue bonds were an invention by Robert Moses and his ilk in the 30s and 40s, and the bankruptcy code did not take effect or did not cover them in Chapter 9. The augmentation of the code in the 70s was done to bring in revenue bonds, and the oddity of the revenue bonds are that the courts have determined and the laws have determined that the revenue streams associated with the revenue bonds do not become property of the bankruptcy estate. In other words, they are safe even through a bankruptcy. And the further oddity is a general obligation bond issued with the full faith and credit, in fact, becomes an unsecured bond in a Chapter 9. Who'd have thunk it? But there's a reversal there, which is why there is a flight, as Guy says, to revenue bonds.
Okay, so others? No one on this side? Oh, right here, yeah. I'm going back and forth this way.
Hi, my name is Peter Henderson. I'm from Reuters News. Judge, I was wondering if you could speak generally about the relationship between a pension fund and a municipal employer, whether that would be something considered a contract, or would it be an extension of a kind of sovereign relationship that would be excluded from bankruptcy?
Well, the question about the relationship of a pension fund to a contract status is something that I think I have to leave to determination later in the case, assuming I knew the answer in the first place.
So the real answer is good try. Okay, Bornstein.
Yeah, I was just curious, Bill. Oh, I'm sorry. Yeah.
Say who you are.
Bill Dan Bornstein. Bill, I was curious. There are a couple things you said that I just wanted to get clarification on. One had to do with OPEBs not having a vested right. I believe in California, there's great debate on that issue, and it depends on the particular OPEB provisions. Do you have any reason to disagree with that?
I think that if you look at the court cases around the country, you will see that the labor unions uniformly take the position that the issue of existing pension benefits covers OPEBs and others. I think there's a lot of people on the bond issuing side who believe that pension plan or the alteration of pension plans means just that, the pension plan, and the rest of it's in play. I think learned jurists like Judge Klein and others will have to sort that out in the near future. If I had to be a betting person, I would bet that ultimately OPEBs are not protected by the constitutions.
Okay, and then I was curious, the 8% ratio you had for California, that was without the pension debt.
That's without the pension debt. Actually, the 8% rate I was quoting was for both Hawaii and California. I think, Hawaii and Massachusetts. I think California, last I looked, was 4.8 or 4.9 without the pension debt. Guy probably knows what it is with the pension debt, but it's much lower than people imagine.
And that would be for the state only, or that would that would not be for the locals.
That is not for the locals.
Okay, and again, the pension debt would not be, whatever you'd add on there would not be for the local pension debt. That would only be for the state pension debt.
Correct.
Okay, thanks.
Slightly better try.
Yeah, and
Your turn. Right there.
With respect to the question he was asking about other post-employment benefits.
I'm sorry, would you say who you are?
Catherine Thompson.
Okay.
At the Superior Court level in this state, retirement health benefits have been found to be vested rights protected by the both state and federal contracts clause, but it does depend on how they're written. And so
it does depend on how they're written and what I'm waiting for. That cheap thing that Judge Klein keeps pulling on me, the supremacy clause. State court decisions are interesting. I want to see what happens when it goes through the federal system.
Okay. Anybody else? One last question, I guess. Yeah, over here. Who are you? And
hi, I'm Russ Fair. I'm the treasurer of the city of Sacramento, 28 years. I'm an investor, got $1 billion we invest in a issuer of debt. I want to follow up on the type of debt, on revenue bonds versus GOs. I don't really think it's bankruptcy protection, but Prop 218 here in California, in an interesting way, has become a credit enhancement. I was interested in Guy's comment, given where investors are, regardless of what you see, the practical reality is investors are buying utility revenue bonds governed by Prop 218. I think it's because 218 keeps unions and elected officials hands off the money, and I wondered if you got it on.
I think there's...
Can you repeat the question?
Yes, so the question is, and I'm going to go to a more generic sense because it's not just in California, it's everywhere.
California is all I know.
All right. So the question is, why do investors want revenue bonds, and I would actually even argue special tax bonds that have protections? And the point was, is it really bankruptcy, or the fact that in some ways it's removed from politics, that they can balance their budgets and so on? I think there are two. One is sort of the easy answer, which is that state and local tax revenues are tied with economic growth. And when you're having a difficult time, particularly in the housing market, local governments are going to have very difficult finances. We're saying very easy stuff that at the cocktail party you'd go, yeah, that's fine. But there's a second order effect too. And I think it gets back to what's the role of a bond in a client's portfolio. So the $1 billion you have invested, you're looking for those bonds to be fairly safe. You don't want them defaulting at the same time that your equity portfolio is cratering, right? And so one of the things that you also like is, and it also gets back to that management question, are the revenues more stable for something like an electric or water, or what we'll call essential purpose revenue bonds, or even a toll road? If you had 100 cars going through that toll, we have a recession now, 97 are going through. Can they raise the toll? More than likely. Can they fix their expenses a lot quicker than a municipality can? And they can basically get back to maintaining their, say, AA average rating. So I think there's two parts to it. One, they are away from all the political turmoil and the volatile revenues and economic sensitive revenues. That's one. And because of all that, by buying revenue bonds, you end up with a more stable bond portfolio, albeit today probably lower yielding, but one that'll hold up better should Mark Zandi be wrong in his book or not, and the economy turns around and heads south. So part of it's that too, diversification.
There's one thing I'd add to this, and that is we were here to talk about, my portion is not just California. I believe that when you look at what's happening in the other 49 states, you have to assume that some of those practices are going to slough over. We go to the other end of the nightmare. Rhode Island is concerned about its municipalities and their continued access to the bond markets. They passed a law which is retroactive, which makes it a felony for any civic official to not pay the interest or principal on an issued bond by that city. Now, what that means is, but stop. Everybody says there's a point here. And the point is, of course, what they've said to the world about Chapter 9s for Rhode Island is, if you file, you're going to pay the interest and principal on the bond. So the only reason you're filing a Chapter 9 at that point is to avoid labor contracts. It's a pretty bold and pretty blunt political statement. But these are the kind of things happening in the other states. Is California immune from these? California is actually new to this business. A lot of the other states have seen it since the Great Depression in the 30s. A lot of these other practices are going to drift on in and be thought about in the near future.
And the judge has a comment.
It's come up in a couple of the comments from Guy and Bill, and I can confirm that there is a provision in the bankruptcy code that does purport to protect special revenue bonds, so that they're not as vulnerable as general obligation, so the revenues are not vulnerable to other uses.
Okay, well, we've used up our time. Thank you very much. It was a great panel.